Representative Dubitsky.
Thank you, Mr. Speaker. Mr. Speaker, it is a basic premise of our democratic society that everyone is supposed to be treated equally. We don't treat people differently based on their religious beliefs. Now, this bill doesn't mention religion or faith, but it's not fooling anyone. This bill is directly and squarely directed at religion. This is directly attacking faith-based pregnancy centers. People who deeply believe that the way the world should work under their deeply held religious beliefs is that they should go out, talk to women who are pregnant, and explain to them certain options that fit within their religious beliefs. In our society, under our Constitution, the government, the state, must not burden or restrict religious conduct. This specifically does, this bill, conduct where people of a given faith have established a facility where they invite people in, invite women in to discuss options for pregnancy. In our society, the state must not burden or restrict religious speech. Well, that's what we're talking about doing. Telling people that even though it's based on their faith, they cannot talk to people and they cannot say certain things because we don't like it. We don't like what a given religion is saying. In our society, under our Constitution, we may not, we must not, we shall not burden or restrict non-religious conduct when it's based on the religion of the person engaging in such conduct. And that's exactly what this bill does. Even if you say putting up a banner on a window or talking to a pregnant woman about how she is, what she is going to do in the next few months is non-religious. The whole premise of the conduct is that that information is being shared by a religious person for a religious purpose. It's a basic tenet of our constitutional law, and it's protected by multiple provisions in our federal Constitution, our state constitution, and under Connecticut state law. Those premises that the state shall not burden religion or religious speech or religious conduct. The First Amendment of the United States Constitution, we all know, protects the right of speech. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peacefully to assemble and to petition the government for a redress of grievances. That's the First Amendment. We all learned it in high school or middle school or even elementary school if we were lucky. And that simple statement protects a lot of different rights. And it's protected those rights for well over 200 years. And it is up to this body not to infringe on those rights that are protected by that amendment. The establishment of religion. What is the establishment of religion, and why is it important here? It's important here because what we are doing in this bill is we are trying to choose which religion is better, and we're trying to burden one over the other. Under this amendment, makes everybody the same. Doesn't matter what your religion, it's based on your conduct. It's based on what kind of facility you have. Now, this bill tries to pick little things and make it look like it's choosing non-religious conduct, but I don't think there's anybody in this chamber, and I'm sure there's nobody in this state who believes that this isn't directed squarely at religious conduct. Now, the Establishment Clause of the First Amendment wanted to make sure, under the Establishment Clause, the founders wanted to make sure that people could exercise their religion and believe as they wished without oppression. They wanted to make sure that the government couldn't choose a religion and couldn't choose non-religion over religion. There's also the Free Exercise Clause. And under the Free Exercise Clause, the state may not restrict or burden the exercise of religion without being subject to very extensive legal scrutiny. So there are reasons why religion can be burdened. There are instances, but it is very, very narrowly tailored, and there are rules to it. Rules that don't exist under this bill, and under this amendment, we don't need to go through those rules because under the amendment, religion is not called out and is not specifically burdened. So, under the Establishment Clause, with the right to free exercise of religion, the clause not only forbids the government from establishing an official religion, which obviously this bill does not do, but it also prohibits government actions that unduly favor one religion over another, and specifically, it prohibits the government from unduly preferring non-religion over religion. That's key. Because in this instance, you could say, well, people who have pregnancy centers that are not limited service pregnancy centers, well, they're not engaging in religious belief. They're engaging in non-religious belief. Fair enough. There are those that would argue that both of them are religions, that one is a religion based on a supreme being and one is a secular religion. And there's case law on that as well. But let's assume for a second that people who are operating pregnancy centers that provide contraception and abortion, let's assume for a minute that they're not religious. That's fine. They are still an entity that the state, under this bill, is preferring to a religious entity. That is a violation of the Establishment Clause. Now, originally, the Establishment Clause only applied to Congress, that when the Constitution was put in place originally, the First Amendment only limited the federal government's actions. But the 14th Amendment was put in place after the Civil War, and in 1940, the Supreme Court incorporated, through the 14th Amendment, the Establishment Clause of the First Amendment. So now it applies to the state too. So the state of Connecticut, under the U.S. Constitution, may not burden religious conduct without a level of scrutiny. Now, we also have our own state constitution. And our own state constitution, Article 1, Section 3, states, "The exercise and enjoyment of religious profession and worship without discrimination shall forever be free to all persons in this state." The religious profession and worship without discrimination shall forever be free to all persons of this state. That includes the operators of what we are calling limited service pregnancy centers. They have a constitutional right under both the federal Constitution and the Connecticut Constitution to freely exercise their religion. Now, there's a right to abortion in this state. We know that. There's also a right to the free exercise of religion. Both competing rights. Neither one of them takes precedent. Neither right overrides the other. So, to protect the right of abortion, the state may not burden the right to the free exercise of religion, and the other way around. So how do we avoid this? How do we prevent one right from taking precedent over the other? We say, treat everybody the same. If we're worried about deceptive advertising, say, any one of these places that advertises deceptively is under the same guidelines, follows the same laws, and is subject to the same penalties. If you say, only the people who are religious are subject to these penalties, then we are unfairly and illegally burdening the exercise of religion, even if it's to protect another constitutional right. This state must not do so. Now, that section of the Connecticut Constitution is further amplified under Connecticut state law, specifically Connecticut General Statutes 52571B. 52571B. I didn't see anything in that in the underlying bill, anything about that. But it essentially says, the state or any political subdivision of the state shall not burden a person's exercise of religion under Section 3 of Article 1st of the Constitution of the state, even if the burden results from a rule of general applicability, except as provided in subsection B of this section. All right? So, even if the burden results from a rule of general applicability. So even if we pass a law that applies to pretty much everybody, general applicability, but it specifically burdens the free exercise of religion in this state, under Connecticut state law, that burden would be illegal. And this bill, the underlying bill, does exactly that. This amendment would prevent that from happening because it would apply equally to everybody. Now, what the state law says is that it's subject to Section B of the subsection B of this section. Okay? So you look down, the next section. How is the state allowed to burden the religion? Section B. The state or any political subdivision of the state may burden a person's exercise of religion only if it demonstrates that application of the burden to the person, 1, is in furtherance of a compelling governmental interest. Compelling governmental interest. That's the first thing that has to be proven.
Excuse me, Representative. Could we ask you to at least stick to the amendment that we're discussing currently on the floor? You're running a wee bit of foul of that. We'd appreciate it if you go back to the amendment and discuss that. Thank you.
Thank you, Mr. Speaker. Mr. Speaker, the second part of this, which relates directly to the amendment, is that that the action has to be the least restrictive means of furthering that compelling governmental interest. So the amendment says that everybody's treated equally, and it provides a means for the state that is less restrictive than the underlying bill. That's what's necessary in order to make this bill constitutional. So two things. One is in furtherance of a compelling governmental interest, and 2 is the least restrictive means possible. Under the amendment, we have that. Under the underlying bill, we do not. Now, another thing that the amendment does is it changes the definition of pregnancy center. And by doing so, it eliminates the ambiguity as to what a pregnancy center is. That's important because with that ambiguity, what we have is a due process violation. And the due process problem is that a limited services pregnancy center would not be able to tell, based on the language in the underlying bill, whether it fits within that definition, how it fits within that definition, or when it fits within that definition. Without a clear indication to the people who are being burdened of how that bill, how that law applies to them, they have no way to tell whether their due process rights are being infringed on. We've also got the biggest problem is equal protection under the 14th Amendment of the Constitution. This amendment fixes that problem. This amendment would fix the inherent 14th Amendment violation of this bill. Now, the First Amendment secures the free exercise of religion. The 14th Amendment prohibits discrimination, including on the basis of religion, by securing equal protection of the law for every person. The underlying bill does not provide for equal protection. This amendment does. This amendment says we're going to treat everybody the same. Everybody who engages in this similar conduct, we're going to treat the same, regardless of their religion. Under this bill, we have a 14th Amendment 14th Amendment equal protection problem. Under the amendment, we do not. If we pass this amendment, we can resolve that constitutional equal protection problem. The basis of the equal protection is that under the 14th Amendment, nor shall any state deny to any person within its jurisdiction the equal protection of the laws. And that's exactly what the underlying bill would do. It would deny what we're calling the limited services pregnancy centers equal protection under the law, because they would be subject to different penalties and a different procedure through a completely different department based on their religion. That's illegal and unconstitutional under the U.S. Constitution. Because under the U.S. Constitution, everybody is guaranteed the right to equal process regardless of the religion or regardless of non-religion. And this amendment would resolve that. Now, when we're trying to determine whether or not there is an equal protection problem in the bill that would be fixed by this amendment, we need to look at the Supreme Court's levels of scrutiny, how they look at a given law. So if this bill were to become law, the underlying bill were to become law, and it were challenged in court without the amendment, how would it be addressed? How would the Supreme Court look at this? And they would look at it based on certain levels of scrutiny that the Supreme Court has created. A basic level of scrutiny is that the challenge statute be reasonably related to a legitimate government interest. Right? Would the underlying bill meet that? Perhaps. We heard testimony that there were, in the public hearing, we didn't hear any testimony of anybody who claimed to have been deceived. The Chairman Steinberg numerous times said that they're not familiar with anybody who has come forward or any complaints that anybody's been deceived. So perhaps rational basis, perhaps not, because the state would still have to prove that there was a legitimate government interest. Under this amendment, that would not apply. We would not have to worry about that if this amendment went through. The court may also apply intermediate scrutiny. In intermediate scrutiny, the state would have to show that the law or policy being challenged furthers an important governmental interest by means that are substantially related to that interest. We don't have to do that under the amendment. Would it satisfy that? Perhaps. The problem is that under this bill, without the amendment, we would be looking at strict scrutiny. Under strict scrutiny is applied whenever a fundamental right is involved. The freedom of religion, the free exercise of religion, is under the U.S. Constitution and under the state constitution a fundamental right. So without this amendment, this underlying bill, were it to become law, would have to satisfy strict scrutiny, meaning that it must be narrowly tailored to serve a compelling government interest, and it must not have, it must be the least restrictive alternative. So narrowly tailored for a compelling government interest and the least restrictive alternative. Well, the amendment clearly is a less restrictive alternative. It just says everybody's treated equally. Doesn't infringe on a fundamental right. So the underlying bill without this amendment would not pass strict scrutiny. Plus, the state would still have to show that this bill was narrowly tailored to serve a compelling government interest. Compelling government interest. There have been no recorded complaints. So what's the compelling government interest? There's no epidemic. There's no huge rash of people being deceived. There's not even any complaints. So what's the compelling government interest that would survive strict scrutiny without this amendment? So far, I haven't heard it. By targeting a small group of faith-based and religious-based entities, this state would be in violation of multiple constitutional rights, constitutional amendments. It would not survive, I don't think, even moderate scrutiny by the courts. And this amendment simply makes the provisions and limitations apply to all groups equally. It prevents targeting based on religious beliefs, and the amendment, with this amendment, the bill would be constitutional. Without the amendment, this bill is simply a political attack against a specific group based solely on their religious beliefs.